Hello, so this is about law, society, and the profession. So, how the law determines when you're insane. Forensic psychology. The intersection between clinical practice and research in the judicial system. One of the goals for forensic psychologists is to determine whether or not a person can be held responsible for their crimes, and if they are capable of defending themselves in a courtroom. Criminal commitment is a process by which someone accused for crime is determined to be mentally unstable, not guilty by reason of insanity, mentally unstable / incompetent at the time of the trial, or guilty but mentally ill. How is this determined? Most states, 70%, hold the defense responsible for proving that a defendant is insane, rather than having the prosecution prove the defendant is sane. What's the difference between those two standards? Which one do you think is more appropriate, proving sanity or proving insanity? Insanity is entirely a legal term. It isn't as simple as showing that an individual is mentally unstable or has had a mental illness. Depending on the rule being used, the actual guidelines by which insanity is determined may vary significantly. So the rules of insanity. We have one, the M-Newgate test. Insanity is determined by showing that a mental issue present at the time of crime prevented the defendant knowing right from wrong. Irresistible impulse test. Insanity is determined by an inability to control one's actions at the time of crime. The Durham test. Insanity is determined when it is found to be their criminal act was the product of a mental disease or mental defect. American Law Institute test. Insanity is determined when it is shown that at the time of the crime there was a mental disorder / defect that prevented them from knowing right from wrong, or prevented them from being able to lawfully control their actions. Things to consider. What are some of the issues or failings you can think of in regards to the 4 previous tests for insanity? Which one do you think is the best method for determining individual insanity? Which one do you think is the worst one for determining individual insanity? Why might we consider eliminating the option for an insanity plea from our justice system? Why might we argue to keep the option for an insanity plea in our justice system? So you can just pause right here if you'd like and just think about some of the answer to some of these questions. So mental incompetence. Consider the following stories from the Bangor Daily News about an ongoing case about Leroy Smith III for murder for his father in May of 2014. So, if a person is determined to be mentally incompetent or mentally unstable at the time of trial, they will be remanded to treatment, until which time they are able to stand trial and comprehend the charges against them and form a logical defense with their legal team. However, just because someone is remanded for treatment doesn't mean they have to cooperate with all the facets of treatment. So, let's see if these articles will open for me. So this one was done in 2016. They say psychologist accused main killer remains delusional. A 26-year-old man accused of killing and dismembering his father in their Gardner apartment in 2014 has made to he would instead enter a plea of not criminally responsible. Assistant Attorney General Don Macomber, who was prosecuting the case, told Martin he would not object to that plea. Wearing a black t-shirt with the words "Fire is with or against you, and so it burns," in large letters on the back, Smith appeared Thursday before Martin in Kennebec County. January 2015, after a state forensic expert testified that Leroy Smith III likely suffers from schizophrenia, paranoid schizophrenia, or delusional disorder, according to Ames. He has since been diagnosed with delusional disorder and believes the primary role of his attorneys is to put him in touch with the heavy metal rock bands so he could tell them he was God. Martin ruled Smith was not competent to stand trial and ordered him committed to Riverview. A year later, under a state law enacted in July, Martin ruled in favor of the motion by the prosecution to involuntarily medicate Smith for 6 months to see if it would affect his competency. I don't really So what we can and cannot make them do. Every individual has a right to treatment, which is exactly what it sounds like. We all have a right to seek and receive treatment of our choosing, regardless of whether we have been voluntary or involuntary committed. Additionally, every individual has the right to refuse treatment. While these guidelines are a little bit more convoluted, they tend to center around our rights to refuse biological treatments, including psychosurgical methods, ECT, and psychopharmaceuticals, at least most of the time. So, civil commitment. Laws on civil commitment vary across the country, but federal rulings have dictated that a civil commitment should only occur in cases where the individual is a danger to themselves or others. A minimum standard of proof has been presented. As to what determines one to be in danger to self or others, or what constitutes minimum proof, the guidelines are varied and non-specific. The disorders that are commonly seen in civil commitment cases include ASPD, so antisocial personality disorder, substance use abuse, impulse control issues, and psychotic disorders. Alternatively, emergency commitment may occur as determined by professionals. The following are ethical guidelines taken from the American Psychological Association. Permission to offer advice responsibly and professionally based on current literature, cannot conduct fraudulent research, plagiarize work, or publish false data, must acknowledge professional limitations, i.e. scope of practice. Legal testimony must be properly assessed using the whole picture and substrated with appropriate examples, research, and resources. Cannot take advantage of or exploit clients for financial, personal, or sexual reasons, and must protect the confidentiality of the clients with few exceptions. Duty to protect, a professional responsibility to break confidentiality when there is a legitimate concern for the safety of the client or those in the general public. So that's it for this video. So thank you for listening.